Good morning, Mr. McLean. Ms. Francois,
Oh,
may I go first, please, with position 9? Thank you.
that's a nice thing.
That's your only one, Milton?
That's Milton, that's yours.
Y'all vote.
I thought you might have to talk for me.
Hi, Mr. Bartel.
Good morning, Ms. Milton. How are you?
I am doing excellent this beautiful day.
Yeah, it is a nice day.
Thank you, Deputy Francois.
You're welcome. Ms. Milton, does, she already been spoken with? She's good?
Mr. Bartel is her attorney.
I spoke. with her.
Okay, okay.
Good morning, Ms. Carr. How are you?
Good morning.
Good morning, everyone. Sorry we're getting started a little late. We are having trouble getting set up on this end this morning. Where are we going to start today?
Good morning, Judge. Good to see you.
Good morning, Judge Morrow. We're gonna start at, ACDC. Ms. Milton has one.
Okay, and let's see, who do we have at ACDC?
That's, good morning, Judge. How are
Good
you?
morning, Mr. Bartels. Good.
That's Ms. Carr, Your Honor, number 9.
And let's see, what are we going to do with Ms. Carr today?
That is going to be a non-negotiated plea, Judge.
Okay. Good morning, Ms. Carr. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Let's see, do we have pretrial on this morning?
Yes, Your Honor, I'm here.
Yes, good morning, Ms. Hardy. May I get the history, please?
Yeah, this defendant has 5 arrest cycles in Georgia. A felony conviction in 2017 for possession of Schedule 1 or 2 controlled substance where they received first offender treatment. It was sealed in 2020. One FTA. Nothing further to report.
Okay. Yes, good morning, Mr. Pierre Thomas.
Good morning, Your Honor. Brief facts of the case, as this is non-negotiated, is that on March 18, 2023, the officer was dispatched to a criminal trespass call at the incident location, that incident location being the McDonald's located at 2350 Cheshire Bridge Road, Atlanta. The victim, the McDonald's employee, stated that the defendant entered McDonald's and began acting in an irate manner. She began by throwing things and knocking drinks around, causing a mess. In the corners of McDonald's, the victim advised that she thought the defendant was having a bad day, but she did not want to say anything to her. The victim eventually the defendant eventually went to the kiosk and placed her order, but did not make a selection of payment method. The victim advised that the order came to the back of the store, but she noticed the defendant did not pay for the meal. The victim advised the defendant stated the manager was going to pay for it, and one of the managers, who was also the witness, one of the witnesses, Mr. Hardy, Blakely Hardy, was preparing to make the food as well, and then noticed that the defendant did not pay. And they both advised each other of the matter. Furthermore, during the situation, the defendant continued to act in an irate state, yelling and causing a disturbance in the restaurant. And she even uttered to the victim that you better call your mama because I'm going to beat your ass. The victim also advised the defendant threatened to throw a drink at her in the process, which the manager and other McDonald's employees witnessed and heard. The defendant was advised that she had to leave several times, but refused to do so. Eventually, when the officer arrived and attempted to place handcuffs on the defendant bucked her shoulders at the officer multiple times and would not stay in place, and showed signs that she was possibly going to take off on foot. And eventually the officer detained the defendant. Our records indicate, or our history indicates, that there's an open 2023 burglary case for this particular defendant. It looks like 23 SC 190037. The recommendation from the state on this case was in regards to counts 1, time served, 211 days time served, credit for the 211 days that she served. And I do believe in regards to the remaining counts, 12 months probation credit, 12 months probation with the balance probated, a stay away from the McDonald's at that incident location, a no further contact with Ayanna Sterling, and if at the appropriate time we can sound for Ms. Sterling in accordance with Marcy's law, that'd be greatly appreciated, and 12 weeks of anger management, Your Honor. And I'm sorry, in count 3, so I'm sorry. So the first thing was for count 1. That was the first thing I uttered was the total. For count 3, 211 days to serve, credit for the time served. Count 4, 211 days, credit for the time served, being 211 days. And they are essentially concurrent with one another.
So she's served already 211 days just on these charges?
Yes, Your Honor.
That is correct, Judge.
And Mr. Bartels, I take it that you take issue with her having to do more than just serving in 211 days. Do you think it should just be time served on all the charges?
That is correct, Your Honor. That's what we're asking for.
Okay, I tend to agree with you on these charges. If she's been in on these charges for 211 days, I believe that's sufficient enough time for each of these charges. So I would give her 12 months to serve 211 days, credit for time served 211 days, balance suspended, and stay away from the Cheshire Bridge location, and Ayanna, no further contact with Ayanna Sterling. Does that meet with your recommendation, Mr. Bartels?
Yes, Your Honor. Thank you. And she does understand she can't go back there or have any contact with Ms. Sterling for the rest of the 12 months.
And Your Honor, if we can sound from Ms. Sterling, that'd be great.
I'm just about to do that, Mr. Thomas. If Ms. Ayanna Sterling is on the line and wishes to address the court, now is your opportunity to do so. Does not appear so. Anything further before I take the plea?
Nothing further from the state, Your Honor.
Nothing further from defense, Judge.
Okay. Ms. Carr, it's my understanding that in case 23 CR 001690E, you wish to plead guilty to criminal trespass, disorderly conduct, simple assault, and willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Were you under the influence of any drugs or alcohol this morning?
No, sir.
Being represented by counsel, are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea, Ms. Carr. 12 months to serve, 211 days, credit for time served, 211 days, balance suspended, stay away from the McDonald's at 2350 Cheshire Bridge Road, and no further contact with Ayanna Sterling. Good luck to you, ma'am.
Thank you.
Thank you, Judge.
You're welcome.
Judge, we can do Oconee County Jail. That's gonna be position 29, Mr. Peoples.
Okay. And who's representing Mr. Peoples?
It's Mr. McLean's case, Your Honor. Okay.
Okay.
People's 29. All right. That's number 3 or not. Your Honor, Peoples is the Oconee County person. So I do need to speak to him. If they could call the telephone, the 404-612-2392, I could tell him what's going on and see what he wants to do with this case.
Okay, do we have anyone at Oconee Jail to assist us?
Yes, sir. What was the number again?
404-612-2392.
Okay, we'll give you the call.
Okay, thank you.
Come on. This is gonna be on the probation calendar, positions 1 and 2, Mr. Marin.
Your Honor, this will be brief because of what the recommendation is.
Okay, good morning, Mr. Mayor, I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Good morning, Officer Allison.
Good morning, good morning, Your Honor.
You can proceed.
Mr. Mayor,
Go ahead.
Mr. Mayor owes, court fines in total $1,420, probation supervision fees in a total of $280, failed to report, via mail, not complete, drug and alcohol evaluation, 240 hours of community service, risk reduction course, or the victim impact panel. He has 4 months and 6 days remaining on probation. Probation is recommended to continue on probation, complete the drug and alcohol evaluation within 30 days, and report to probation within 48 hours upon release.
What's been the problem?
I didn't get a chance to speak to him yesterday, Your Honor. I did speak extensively with his family about his future prospects of success, and they were very up about that. But Mr. Marin, the problem that you've had so far has been what? The court is wondering.
When I first took my plea, it was through text message, so I really never got the stipulations of my probation, like in writing or anything.
I don't know if you've had cases before, but if you take a plea, even if it's by text, as you say, you have to go to the clerk and get the conditions and understand your plea.
Yeah.
This is this. I can't.
15
I think he wants to tell you what the state's.
Okay, right. Atlanta.
You've got.
Okay, good. Now, Your Honor, we do have a good address for him in Hampton, Georgia, and we do have a phone number that he'll be using. I also have the sister's phone number in our file, so the contact information will be good.
I still don't have a good understanding of why he hasn't reported or done anything in the last, this is a 2017 case. I don't understand what the response to my question was, Mr. McLean. Why hasn't he done anything? And if I place him back on probation as opposed to just keeping him in custody, how he's going to make sure that he completes what we've asked him to do when he hasn't done so in the last 3 or so 4 years.
Right. Basically, I understood him to say the nature, the way or the methodology in which they took the plea, he felt uninformed about what to do next. And that's basically, I think, what his answer is. Is that correct?
Yeah, and also it was, I just took a plea like a year ago, or less than a year.
I'm sorry, what?
I just took a plea like less than a year ago, a couple months ago.
Okay.
It hasn't been,
All right, so let's talk.
it was an okay, so they just brought it back up. That's why it's so long.
Okay. A plea came up last year and so it was noted that this case was still open or still on probation. So basically what you need to do is tell the court whether you think you can finish this
Yeah, I can.
with all the conditions.
Yes.
Okay, because what I'm gonna do, Mr. Mayor, is that if I do decide to place you back on probation, then you are going to have to complete everything promptly. If you miss one time, with checking in with probation, then you're gonna be brought back here and I'm gonna revoke the balance. If you do not, comply and start, doing the terms of the probation, in a timely manner, I'm gonna have you back here and revoke the balance. So I don't want to set you up to fail. Either I revoke the balance today and just let you be done with this, or I return you to probation. And if you don't report and if you don't do what you're supposed to do, I'm gonna bring you back and you're gonna have the balance revoked. You understand what I'm saying?
Yes, sir.
Okay, so Officer Allison, if he does not report one time to probation, bring him back. If he does not start these classes within the next, I'm going to say 20 days, bring him back. If he comes back and he has not started to either pay these fines or to do the rest of what he's supposed to do, bring him back, and I will revoke the balance at that time. So
Okay.
that'll be the order of the court. Good luck to you, Mr. Mayor, and I hope not to see you again.
Okay, thank you.
Thank you, Your Honor. That concludes probation. Probation, free though.
Yes, have a good day. Thank you, Officer.
You
Allison.
too.
Positions 2 and 3, Mr. Augustus.
Negotiate it, please, Mr. Bartel.
That's correct, Your Honor.
Good morning, Mr. Ellisford. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Could you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you, sir. Yes, Mr. Pierre Thomas.
Your Honor, the negotiated plea as negotiated between the defense and the state, Your Honor, is on count 1. It is to be 12 months probation, to be concurrent with count 2, and to have restitution to be open for 30 days. The negotiated plea on count 2 is 12 months probation to serve 30 days, credit for the 15 days that he's already served, balance to be probated, 12 weeks of anger management, 40 hours of community service, no further contact with Rebecca Scott and Savannah Scott. A stay away from the location of 1364 Bell Smith Drive in Alpharetta. And if at this time we could sound for the 2 victims, that'd be greatly appreciated in accordance with Marcy's law.
Thank you, Mr. Pierre Thomas. Is it Bell Street? Bell Smith
Yeah,
Drive?
B-E-L, Bell Smith, B-E-L-L-S-M-I-T-H.
Okay, I'm just wondering because the calendar says Ball Smith. I just want to make sure that I give him the right place to stay away from.
I think that I'm going off of the warrant.
Okay,
It's Bell Smith, Your Honor.
okay, very good. If Ms. Rebecca Scott or Savannah Scott, you all are on the line and wish to address the court this morning, now is your opportunity to do so. Doesn't appear so. Mr. Bartel?
Yes, Your Honor, we would ask the court to accept the negotiated plea. It looks like there's nothing else from Fulton County holding in Mr. Augustad. I have advised him of his options, and we are aware of the restitution. He did tell me that he had taken care of the damage, so that should not be an issue, but we understand that could be looked at within the first 30 days to verify that. He has not had any further contact with Ms. Scott or her daughter in some time, so that is not an issue. And this address is not his residence. He lives in Roswell, so we understand the no further contact order either. We would just ask the court to accept the plea agreement.
Any objection, Mr. Pierre Thomas, to the probation going non-reporting upon completion?
No objection, Your Honor.
Mr. Augustad, it's my understanding that in case 23 CR 0000002F, you wish to plead guilty to criminal trespass and simple battery. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury. on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced you or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Arlestead. Let's see, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get that complete, the sooner you won't be on reporting probation and the sooner you won't have to pay those fees, okay?
Yes, Your Honor.
And it's my understanding that position number 3 is going to be null process, is that correct?
That is correct, Your Honor.
All right, good luck to you, Mr. Arlestead.
Thank you.
Thank you, Judge. That's just.
Okay, yeah, because I never got a notification.
Positions 4 and 5, Bach.
You can have a seat.
What's the announcement, Mr. Ball?
That's reset to jail jury, Your Honor. We'll enter a not guilty plea.
Okay. Has he already been arraigned, or would you like to file a written waiver?
Yeah, I don't believe he's been arraigned, Your Honor. We'll waive arraignment. He's aware of what the charges are.
Okay, so if you'll file a written waiver for me, Mr. Bartels, please. And Mr. Bond, as such, your case will be returned to the division judge, and you'll get notification of the next hearing date, sir. Good luck to you.
All right, thank you. Okay, I'll get that to the court when I get back in the office.
Okay, that's fine. Thank you, Mr. Bartels.
Good luck, sir.
Position 11, Co.
This is also going to be a non-negotiated plea.
That is correct, Your Honor.
Good morning, Mr. Coe. I'm Judge Eric Mara. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do, Your Honor.
Thank you. Can you raise your right hand for me? Swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. May I get Mr. Coe's history, please?
Okay, so Brady people.
This defendant is a multi-state offender with arrests out of Georgia, Virginia, and Pennsylvania. Felony conviction in 2014 for possession of meth. A 2012 felony conviction out of Virginia for grand larceny. And 4 probation violations. Nothing further to report.
Mr. Pierre Thomas?
Your Honor, brief facts, as this is a non-negotiated plea, that on Monday, October 9, 2023, the officer arrived at an armed person call for service at the incident location of the High Museum, that being located at 1201 West Peachtree Street, Northwest Atlanta, Georgia. The security officer, David Dye, reported that they received calls from the staff member that there was a white male with a blue shirt pushing a cart, waving a knife at people and shouting obscenities. Mr. Dye, the witness, was tracking the location of the defendant and giving the officers updates while the officers were canvassing the area in hopes of catching the defendant. Officer received reports that the defendant was at Whole Foods, a gas station, and at the Art Center MARTA station. Every call that came in reported a white male wearing a blue hoodie pushing a shopping cart that was swinging a knife directly at bystanders and roaming the downtown area. Finally, the officer received a call from the Georgia State University Police, whom reported that the white male in the blue hoodie, armed with a knife and a shopping cart, had been detained. A Georgia Tech officer confiscated a knife, which the defendant was carrying in his hand when detained. The defendant also had a second knife on his person at the scene. At the scene, the officer interviewed one of the victims, the victim Flavio and victim Christopher Underwood. Flavio stated that he was leaving work at One Atlantic Center, located at 1201 West Peachtree Street, as he approached his car, whom his husband Christopher Underwood was driving. He observed a white male with a blue hoodie yelling obscenities and unintelligible words. Christopher got out of the car and informed Flavio that the defendant had swung his shopping cart into their car and damaged the rear driver's side door. Therefore, Flavio approached the defendant, but realized the defendant had a knife, which he proceeded to wave towards Flavio. Your Honor, the state's recommendation in this case, given everything and the criminal history, is 12 months on count one, 12 months probation, balance probated, consecutive with count two, MHET, no knives or guns, stay away from the following locations: that 1280 Peachtree Street, northeast location, that 1255 West Peachtree Street, Atlanta, that 1201 Peachtree Street, Atlanta, the 2214th Street, Northwest Atlanta location, no contact with the victims, Christopher Underwood and Flavio Underwood, and restitution to remain open for 30 days. As it relates to count two, 12 months probation to serve 120 days, credit for the 22 days that he's already served, balance probated. And count three, 12 months probation to serve 120 days, credit for the 22 days that he's already served, with the balance probated, and that is to be concurrent with count two.
1280 Peachtree Street, what location is that?
The 1280 Peachtree.
Yes.
That's the high, so the high, 1255 West Peachtree Street. What is that?
I believe that's the shopping center where the Whole Foods is located. Yeah.
And 2214th Street. What location is that?
I believe that.
Sorry, I didn't mean to interrupt, Your Honor. 1255 West Peachtree is the location of MARTA.
That's Marta. Okay, thank you, Ms. Marta.
And what's the other address?
It's 2214th Street.
That's the Hugh at Midtown. So it's an apartment complex.
Thank you, Ms. Falk. I just want to make sure that he knows where he can't go back to, Hugh at Midtown. So the High Museum, that MARTA at that location, and the High and the Hugh at Midtown. Is that correct?
That is correct.
Three locations. Okay, thank you. Mr. Christopher Underwood or Flavio Underwood, if either of you are on the line and wish to address the court, now is your opportunity to do so. Mr. Bartels?
Yes, Your Honor, thank you. We would ask the court to accept Mr. Coe's plea. He does disagree with some of the allegations, particularly that he targeted any one particular individual. However, we do stipulate that there would be a factual basis for a plea to the charges. Mr. Coe advises me that he lives in Ranger, Georgia, and he is employed full-time. He does home remodeling for Kirkland and Son. It's a home remodeling organization. And we are in agreement with all of the state's recommendation, except for the amount of days to serve. The state's recommendation is 120 days. I believe he's already served 22 days. He was booked October 10th. We would ask the court to consider a sentence of 60 days to serve. That's what he wants to ask for, Judge.
Okay. So, Mr. Bartels, if I allow him to, if I don't take the recommendation and take your request of 60 days, I would have him do, in addition to what the state's asked, an additional 25 hours of community service or 25 hours of community service.
Yes, Your Honor. He would accept, that. That's agreeable.
Okay. So let's see, if nothing further, uh, from anyone, I'll go ahead and take the plea. Mr. Coe, it's my understanding that in case 23 CR 006100H, you wish to plead guilty to disorderly conduct and 2 counts of simple assault. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor, I understand.
Has anyone forced or coerced you to plead guilty?
No, not in any way.
Okay. Let's see. I'll accept the plea, Mr. Coe. For the for count 2, the simple assault, 12 months to serve, 60 days credit for time served, 22 days balance probated, and MHET, 25 hours of community service, no knives or guns, stay away from those locations that we have already mentioned, and no further contact with Christopher or Flavio Underwood. I'm not sure what the restitution is. I'm going to let them handle that in a civil way if they're seeking restitution. I'm not going to require the restitution at this point in time. For the count 3, the other simple assault, the same as for the first simple assault and for the disorderly conduct, 12 months to serve, 60 days credit for time served, 22 days, and the balance will be suspended on that. Okay, any questions?
No, Your Honor. Thank you, Judge. Thank you.
All right, good luck to you, Mr. Coe.
Thank you, Your Honor.
You're welcome.
Positions 15 and 16, Mr. Farrell.
And what are we doing with Mr. Farrell this morning?
It's a negotiated plea, Your Honor.
Okay. Good morning, Mr. Farrell. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Farrell. Mr. Pierre Thomas.
Your Honor, the recommendation from the state is for Mr. Farrell to serve 12 months on probation, to serve 160 days in custody, credit for the 81 days that he's already served in custody, for the balance to be suspended, to have no further contact with Candan, Candan, Davis, to stay away from the location of 870 Mason Turner Road, Northwest Atlanta, Georgia. And if at this time we can sound for Mr. Davis in accordance with Marcy's law, that'd be greatly appreciated, Your Honor.
Okay. And position 15 will be null pros.
Yes, Your Honor.
Mr. Candan Davis is present and wishes to address the court. Now is your opportunity to do so. Mr. Bartels.
Yes, Your Honor. We would just ask the court to accept the plea agreement. As the state indicated, he has served 81 days. It looks like that was in 2021 and sometime in 2022, as well as the current one. So he indicates he is employed full-time as an electrical contractor. And we would just ask the court to accept the negotiated plea. I'm advised that he hasn't had any contact with Ms. Davis in quite some time.
Okay. Mr. Farrow, it's my understanding that in case 21 CR 003403C, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Farrow. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
We have positions number 19 and 20, DeMarcus Jackson.
Both me.
Okay. And this is going to be negotiated plea.
Yes, Your Honor, the state has agreed that it could be a NOLO and it's a negotiated plea as to what the state has sent over.
Okay. Good morning, Mr. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you, Mr. Jackson. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is 12 months, probation served 28 days, credit for time served 14 days. That is from July 11th, 2022 to July 12th, 2022, and then October 20th, 2023 to today. Balance suspended in a stay away from Rockin' Taco at 3247 Roswell Road Northeast. State would ask the defense to stipulate to venue, factual basis, and identification.
And Your Honor, we do so stipulate to those three elements for the purposes of the plea, and he does ask the court to accept his negotiated plea of NOLO contendere.
Okay, and position number 20 will be null pros.
Yes, Your Honor, and the state does not object to the NOLO plea. We looked at his history, and his last NOLO plea was over 5 years ago.
Okay. Mr. Jackson, it's my understanding that in case 22 CR 004478F, you wish to plead NOLO to criminal trespass, is that correct? You're on mute, Joe Courts.
Yes, sir.
Thank you. You've been represented by counsel. Are you satisfied with his representation?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading NOLO to it, you're giving up your right to a trial by jury?
I'm good with the NOLO.
Okay, you don't want a jury trial, do you, Mr. Jackson?
No, sir. I'll take the NOLO. What you said earlier.
Okay, so I'm just wanting to make sure that you understand that you do have a right to a trial by jury, but because you're pleading NOLO, you're giving that right up. You understand that, Mr. Jackson? You understand? Okay.
Yeah.
Has anyone forced you or coerced you to plead NOLO?
No, sir.
Okay, I'll accept the NOLO plea, Mr. Jackson. Good luck to you, sir.
Judge, we're ready for Oconee County Jail, position number, going back to Peoples, position 29.
Okay, thank you.
And if I can make an announcement, I can speak with Mr. Daniels, number 12 and 13. He's at South Annex. If somebody could just call the phone when y'all get a chance.
Where is he, Mr. Bartels?
He's in Union City, Your Honor, South Annex.
Oh, South Annex, okay.
Number 12 and 13. I just need to talk with him.
Okay.
We do this case.
Is it South, I don't know if this, is it South Annex on?
I don't know. I'm just making the.
Okay, oh, great, okay, Mr. Bartels. Let's see, what are we doing with Mr. Peoples this morning?
Your Honor, that is a negotiated plea of guilty on both counts, and we're ready to go forward.
Okay. Mr. Peoples, good morning. Can you hear me okay?
Yes, sir.
Yes, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Peoples. Yes, Ms. Falk.
Yes, Your Honor. On count one, the state's recommendation is time served 122 days, credit for time served 61 days. That's going to be September 22nd, 2020 to September 25th, 2020, and then September 5th, 2023 to today. Count 2, 12 months probation, served 122 days in jail, credit for time served 61 days, balance suspended. And the state would ask the defense stipulate to venue, factual basis, and identification.
And Your Honor, we do so stipulate as those three elements for the purposes of this plea, and we do ask the court to accept the negotiated plea.
Okay, Mr. Peoples, it's my understanding that in case 20 CR 004765A, you wish to plead guilty to obstruction of a law enforcement officer and carrying a weapon without a license. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this
No,
morning?
sir. No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Peoples. Good luck to you, sir.
Thank you.
You're welcome.
Position number 34, Tremaine Pierce.
Okay.
I'm sorry, what number did they say?
This is number 34. Let's see, there's a DA transfer, Ms. Falk.
Your Honor, let me just, I was just sending a message. Hold
Okay.
on. Position 34, we did request a DA transfer. We are still waiting for the medical records from the victim. We believe, although that we don't believe that it would go forward on a robbery. However, based on the severity of the injuries listed in the warrant, as well as the information provided by the victim, we do believe there could be an aggravated assault here, but we need the medical records to support that. And so we are still waiting. The victim did request the medical records from Emory, and we just need to get those medical records in. I don't know, just to refresh your recollection, Judge Morrow, this is the victim who came online about a week or so ago and stated that he had been struck in the head by the defendant, was concussed, and was stating that he was severely injured and had to be taken to Emory Hospital.
Okay. When do you believe that you'll get those medical records in?
Our hope is that we can get them in within the next week. I have asked Ms. Maldonado to speak with our victim and make sure he can secure those medical records so that we can get them to the DA's office and have them make a determination based on the medical records.
Okay, and I did issue him a bond the last time I saw him, correct?
The bond is currently set at $2,000, Your Honor.
Okay. Mr. McLean, anything further, Ms. Falk?
Yes, Your Honor, just to remind you, this was going to be a plea, but based on the statements of the victim, we did hold off on pleading this case out until we could get an answer from the DA's office.
Okay. Mr. McLean?
Your Honor, because of the additional delay, the defendant would like to ask the court to consider a signature bond at this time, because he would like to not wait in jail any further. He cannot afford the $2,000 bond.
Okay, based on what I remember that I heard, I think a $2,000 bond, surety bond in this case is adequate for this case. I will reset it one further time, and hopefully they'll have the records in by next Tuesday. But if they don't have the records in, unfortunately will not be on the calendar next Tuesday. But it would be my hope that you all would go forward at that point in time. So I'll reset for 1 week to, what date is next Tuesday?
The 7th.
The 7th.
Until 11/7. So we'll see Mr. Pierce back next Tuesday.
Okay, Your Honor.
Thank you.
Position 1, Anderson.
Mr. Bartels, are you going to file a waiver in this case, or do I need to arraign Mr. Anderson this morning?
We'll file a waiver of arraignment, Judge, and just ask for a reset to jail jury.
Okay, good morning, Mr. Anderson. Let's see. Your case is going to be returned to the division judge and you'll get notification of your next hearing date, sir. Okay? All right. Good luck to you, Mr. Anderson.
Thank you, Judge.
Position 17 and 18 Harrison.
Negotiated plea, is that correct?
That's correct, Your Honor.
Good morning, Mr. Harrison. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Yes, Mr. Pierre.
Sorry, I started talking but was muted. Your Honor, the state's recommendation in this case is for the defendant to serve 12 months probation, to serve 30 days in custody in accordance with the statute. Credit for the 8 days that he's already served. Looks like from October 24th of this year. A stay away from the 2525 Piedmont location. That is Piedmont Road Northeast. That is the Home Depot. 40 hours of community service and the completion of a MHET. And if we could have the defense stipulate to venue, factual basis, and identification, that'd be greatly appreciated.
Yes, we would stipulate to those three.
And position number 18 will be non-crossed.
That is correct, Your Honor.
Okay, Mr. Bartels.
Yes, Your Honor, we would ask the court to accept the negotiated plea. I've talked with Mr. Harrison and advised him of his options, and he does want to go forward with this plea. As the state indicates, he's been incarcerated since the 24th, and he does not appear to have anything else holding him in. So we would ask the court to accept the agreement.
How much the jail time I served when I first got charged?
When was that?
You were charged in 2020.
Well, if you went to jail, you would have.
Is there any way you could just do it to time, sir?
No, it has to be done in the statute.
If you need time to speak with him, I'm happy to give it to you, Mr. Bartels.
That's okay, Your Honor. He had a question about the minimum time under the statute.
Okay. So are we ready to proceed with the plea?
Yes, Your Honor.
Okay. Mr. Harrison, it's my understanding that in case 20 COV 000281, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, ma'am. Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Was that a yes?
Yes, sir.
Yeah, you just gotta raise your voice. He's got a quiet voice, Your Honor.
Okay, I understand. I just want to make sure that I'm hearing him correctly. Has anyone forced or coerced you to plead guilty, Mr. Harrison?
No, sir.
Okay, I'll accept the plea as negotiated. Let's see, when you complete the terms, meaning that you get the MHET done and 40 hours of community service done, I'm going to have the probation terminate. So the sooner you get that done, the sooner you're not going to be on probation, okay?
Thank you, Judge.
All right, good luck to you, Mr. Harrison.
Position number 36, Mr. Eulis.
And this is going to be a non-negotiated plea.
Mr. McLean? This is 36, Your Honor?
Yes.
Yeah, 36. Gotcha.
Okay, that's a non-negotiated. Okay, Your Honor, 36 is a non-negotiated plea.
Okay. Let's see. Good morning, Mr. Eulis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir?
You're doing this by video. Is that okay with you?
Yes, sir.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Ms. Hardy, is there a history?
Yes, Your Honor, bear with me. I'm just receiving this history.
Okay.
Okay, this defendant appears to have 49 arrest cycles in Georgia. Misdemeanor conviction in 2014 for obstruction of law enforcement officer. Probation violation, 1, 2, 3 probation violations. Terroristic threats and acts felony conviction in 2019. And 1 FTA, nothing further to report.
Ms. Falk?
Your Honor, we actually have FTAs from 2016, 2018, 2019. We're also showing a parole violation from the Georgia Department of Parole Board for aggravated assault. He has a burglary from 2018, multiple parole violations, and he has been arrested for battery, theft by shoplifting, and driving while license suspended previously. He also is, it looks like he also has some history out of Ohio, and may be wanted out of Ohio. So we do need to double check on that. This incident happened October 7th of 2023 at the Rainbow Store located at 2064 Campbellton Road Southwest. Officers responded to that location in reference to a male involved brandishing a weapon. The call remark stated the male pulled out a gun on store employees after he was asked to leave the store because he was acting belligerently and causing a disturbance in the store. He was identified as the defendant and was detained a short distance away from the incident location, and a positive identification was made by the store employees who called 911. They stated that the defendant had a silver pistol that he pulled out on them. It turned out that the pistol was a replica pistol, which is the only reason he's not charged with possession of a firearm by a convicted felon. And after speaking to the defendant, he gave the name of DeMarcus Thurman with a date of birth of 9/18/1984. Given that he looked substantially older than that, they were able to finally find his correct name of Eric Ullis with the date of birth of 2/19/1970. As I stated, he did have a wanted notification out of Ohio, but they did state that they would not be extraditing, and he had a parole violation for aggravated assault. Based on the fact that this defendant pulled even if it was a replica pistol, pulled a weapon on individuals at this store, we do have some serious concerns, especially when you combine that with his history that shows he has a previous history for aggravated assault. For that reason, we are asking for 12 months probation. That would run consecutive with count 2 and a stay away from 2064 Campbellton Road. No further contact with Jamisha Wimbles and Alicia Mack. Those were the individuals at the store. Count 2 is 12 months served, 365 days. Credit for time served. He is served from October 7th of 2023. So he served 18 days at this point. And count 3, 12 months served, 365 days. Credit for time served, 18 days from October 7th, 2023. So that would make a total of 24 months served, 365 days, credit for time served, 18 days. Stay away from the Rainbow Store at 2064 Campbellton Road, and no further contact with Jamisha Wimbles and Alicia Mack. And again, that is in recognition of his extensive history, as well as the fact that although it was later determined to be a replica, he pulled a gun on 2 individuals at that store.
Okay, let's see, Mr. McLean.
Certainly, Your Honor, he does understand the definition of simple assault, and he is willing to plead guilty to it today. His version of the facts has to do with him not being an aggressor, and that he was being put upon by other people in the store, and in a sense, because of his disagreement with the fact version, it doesn't quite, it's in his best interest, he feels, to go forward with a guilty plea today anyway, and to make it a non-negotiated plea. He feels, Your Honor, with the toy gun, the replica silver pistol, that I explained to him and discussed with him, he was putting himself in danger. But nobody else. He would like to ask the court to consider a time served plea. He's been in several weeks. And Your Honor, this parole business about, he showed me papers that indicated that his parole was expiring or had expired already right about this month. So it was very close on the end of the parole. The parole hold he showed, but the parole hold says that there's an expiration date, which I believe has just passed. So he would like the court to consider a time served plea, and if not time served, something in the nature of 2 months at the most.
So tell me more about, I don't understand the factual circumstance as far as why the replica was pulled, what the dispute was about, anything that can help the court with that?
Yes, Your Honor. So the individuals at the store stated the defendant was asked to leave the store because he was behaving belligerently and causing a disturbance. And at that point, that is when he pulled out a gun on, or what they believe to be a gun on the store employees, and then was later determined to be a replica after he was arrested. While he was in the vehicle, I will say that while he was in the officer's vehicle, while he was walking into the precinct, he started banging his head on the wall. And so there is some, at least from the officer's observation, some corresponding behavior that tied into the kind of behaving erratically. And so that is the basis of the occurrence that led to him pulling the replica pistol. And we would like to sound, because I did neglect to do this, for both of the victims, just in case they are present here in court, and that's going to be Miss Wimbles and Miss Mack, Alicia Mack and Jamisha Wimbles.
If either of those parties are present and wish to address the court, there's an opportunity to do so. Okay. Mr. McLean, anything?
Yes, Your Honor, there is a background to what was leading up to this. His wife was recently found dead, and he had bought a dress. Rainbow is a store in which they sell clothing for women. And so he was there because he was trying to return a dress that it turned out that because his wife was cremated, they didn't need the dress for a casket type of funeral. So he was returning the dress. And of course, he was in a period of time then when he was very upset about the death of his wife. And he went in there and they accused him of shoplifting because there he was with the dress in his hand. I don't think he had the original receipt. So that he gets accused of shoplifting. And then as the court may imagine, or as I imagine, a verbal dispute started about you're shoplifting. No, I'm not. A lot of yelling. He says he was pushed down by them first, by store employees. He does not know the particular names of which store employees. So whether it was these two particular people or whether somebody else pushed him down.
Excuse me, Mr. McLean. Excuse me one moment. Mr. Seymour, this is a court proceeding. You cannot sit there, either turn your camera off or respect the court and not be eating while this is going on. Thank you, sir. I apologize, Mr. McLean. Go ahead.
No problem. So basically, people were upset, including him, including the store employees. If that offers any understanding of the mitigation that I'm trying to offer to the court about why there was this dispute and why this toy was displayed.
Okay. This disturbing at a toy or not, there should, these are just people that are trying to do their jobs in a store. It appears to me that there may be some mental health issues, so I would require that there be some mental health evaluation and treatment. I'm not sure if there's some anger issues. I would require that there be 12 weeks of anger management. I would reduce the time in jail to 150 days because I think that he would be better served by getting some type of help. I would have everything run concurrent, so it would be 12 months total. I would have him report the entire 12 months. No drugs, alcohol, or weapons, once he gets on probation. So that would, and of course, stay away and no further contact. So if that's something that he wants to accept, then that would be the order of the court. You need to talk to him, Mr. McLean.
Yes, Mr. Eulis, are you in a location where they can have you call me on the phone so I can double check with you your understanding of the court's inclination to see if we're going forward one way?
Sir, I don't understand. I couldn't hear what.
I will explain everything you don't understand if you can get on the phone
He
with me.
said he couldn't hear what the sentence was.
That's what I'm going to explain to him in detail.
I don't have your phone number, sir.
Okay, it is 404-612-2392. It's the desk phone over here. We'll have to.
It's what? It's what?
404-612-2392.
That's not your phone number. He need your phone number, not the courtroom phone number.
Our phone, we don't have any other way.
Look, I mean, it's my right to know what, I don't want to.
No, we're gonna do that for you, Mr. Eulis. So
Thank you very much.
Why can't we call the courtroom phone number? Is there a reason?
I think
Sir?
I think it would be a good idea to call the courtroom phone.
Who's with me at jail courts? iPhone.
I couldn't hear you.
Can you all just call the courtroom for me?
Yes.
Okay, so
So-
go ahead and call, and Mr. McLean will talk to him. We'll go on to someone else while they're
right.
having a conversation. Thank you.
Okay.
We might have to pause for a minute while I do that. The other cases might all be mine, Your Honor. I think I got. Mr. Bartels may have a couple. Very good.
All the rest of them are his.
I think.
Judge, the remaining of the positions that I have is gonna be for Mr. McLean, so we're gonna have to.
Okay, can we see if is someone else getting on today? Are we gonna have someone from ACDC or South Annex?
I believe that's it for South Annex.
Yeah, there's Mr. Daniels.
I'm sorry, I thought you were referring to, I'm sorry, I was thinking about ACDC.
Okay, sorry. Okay.
South Annex. Still have-
Can we see if we can get the South Annex on?
The only thing with that, Judge, they have to call Mr.
Oh.
Bartel.
Mr. McLean's on the phone now.
Oh, okay, all right, so,
But once they get him, they'll give you a call.
Okay.
all right, so we'll have to be in recess then until we're ready to move forward, I guess.
Okay.
Okay, so just let me know when you all are ready to move forward.
It should be done before too long. So let's pause for a second.
Yeah, they had fun, on recess.
Right. We have the announcement. Your Honor, we have an announcement.
Yes.
36 will be, he's gonna stick by his plea and accept, he understands what the court has outlined, and that is, quite acceptable.
Okay.
I explained to him the 12 weeks anger management while on reporting probation for the entire remainder of the 12-month period, approximately a 10-month probation. MHET, 12 weeks anger management, and stay away, no contact. And we talked about approximately when his probation would start and approximately when it would, when he would be released from jail, which I calculate to be approximately 57 days from now.
Okay, so we'll take that when he comes back on the line. Is there, who do we have beside you there?
This is gonna be position 30, Perry.
So can we, as we wait for Mr. Ulis, can we go back, can we go to position 30?
Yes, Your Honor, this is a negotiated plea.
Okay, good morning, Mr. Perry. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down, Mr. Perry. Yes, Ms. Falk.
Yes, Your Honor. State's recommendation is 12 months probation, serve 18 days in jail, credit for time served 9 days. That would be from October 23rd, 2023 to today. Balance suspended, no further contact with Doreen Weaver, and stay away from 4755 Yates Road, apartment 5K. We would like to sound for Ms. Weaver.
Ms. Weaver, if you're on the line and wish to address the court, now is your opportunity to do so. Yes, Mr. McLean.
What was the offer? I have on my offer sheet, NVCs, which I took to mean no violent contact. Was that a typo?
Just a moment. In the meantime, we would like to ask this defense to stipulate to venue, factual basis, and identification.
We do so stipulate,
Say
yeah.
something really quickly.
Right, we do.
What is the relationship between him and Miss Weaver? It looks like they were, doesn't look like they were living together, but it also looks like there was more than a friendly relationship.
I think they're cousins or sons. Cousins. They're related, they're cousins.
And I just need to look really quickly at Miss. Hold on. Your Honor, if you can just give me a moment, because there may be something that doesn't allow for contact on her side. Okay, we have no objection to no violent contact. I will state, however, Your Honor, for the record, that we have not received from Miss Weaver one way or the other whether she would like to have contact.
Okay.
And Your Honor, he understands that even if it is no violent contact, which is less restrictive than the other kind, nonetheless, he is promising to stay away from apartment 5K, to stay away from 4755 Yates Road.
Okay, anything further, Mr. McLean?
Nothing further.
Mr. Perry, it's my understanding that in case 19 CR 002962C, you wish to plead guilty to simple battery, is that correct?
Yes, sir, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir, Your Honor.
I'll accept the plea as negotiated, Mr. Perry. Good luck to you, sir. Okay, we can go back to jail courts, to Mr. Eulis. You can unmute yourself there, jail courts for me, please. Okay, anything further on Mr. Eulis before I, take the plea?
Your Honor,
Nothing.
I discussed what the court outlined and he understands and wishes to go forward.
And nothing from the state, Your Honor.
Okay. Mr. Eulis, it's my understanding that in case 23 CR 006071E, you wish to plead guilty to 2 counts of simple assault and giving false information to law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Eulis, for count 2, the simple assault. The court's sentence will be 12 months to serve 150 days, credit for time served, 18 days, balance probated, an MHET, 12 weeks of anger management, no further contact with either Jamisha Wimbles or Alicia Mack. Stay away from the Rainbow Store located at 2064 Campbellton Road. No drugs, alcoholic weapons while on probation. The same sentence for the count 2 simple assault, for the given false information, 12 months to serve, 18 days, credit for time served, 18 days, balance suspended. Okay, no questions. Good luck to you, Mr. Eulis.
Yes, sir.
Your Honor, I do have another engagement that I have to depart for. Supervisor Anna Allen will be handling the remainder of the cases of my cases on the calendar, so with that may be excused.
Yes, Mr. Will I see you this afternoon?
No, you will not, but you will see me on
Okay.
Thursday if you are here. On Thursday.
All right, have a good rest of your day.
Thank you.
Okay. And welcome, Miss Helena Allen. Good to see you as always. Who do we
Good
have
morning. I
next?
apologize. I'm having some technical difficulties.
Okay, good morning. Who do we have next?
This is position 21, Jenkins.
No, that's a not guilty and a request for a bond reduction.
Okay, do we need to arraign him this morning? Mr. McLean?
I'm sorry, could we go on mute for just a moment?
Was A suspended? A was suspended on the last, correct?
Was what suspended?
A, the willful obstruction on the one you just did.
Yes.
Okay.
Are we ready for position number 35, Michael Tuggle?
No, we're not just quite yet. Mr. McLean is speaking with his client in courtroom 2, so we'll be with you as soon as we can.
Which one is Mr. McLean on there? Which one we voting on? I mean, who is Mr. McLean speaking with?
Position 21.
20.
I think Marcus Jenkins.
Come on in.
We're gonna withdraw our request. Thank you, Your Honor. That was a good discussion that we had. We are withdrawing the request for a bond reduction. It is simply a not guilty. We will waive the formal reading of the accusation. It has to be put on the jail jury.
Okay, you'd like me to arraign him this morning?
Yes, Your Honor.
Okay. Good morning, Mr. Jenkins. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yep.
Thank you. You can place your hand down, Mr. Jenkins. You've been charged in case 23 CR 006277G with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, Mr. McLean, that you're waiving formal reading of the accusation. Is that correct?
Yes, it is, Your Honor.
How do you plead, Mr. Jenkins? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
Thank you.
Okay. Who do we have? Yes.
Position number 35, Mr. Michael Tobin.
Okay. So do we need to, who's representing, we need a social worker visit? Is that my understanding on position 35?
That's correct. He really does need a social worker visit, Your Honor. We talked about one aspect, and I discussed it with the state, and it turned out that he won't, because of the charge not being dismissed, he won't be eligible for PAD in that sense. But we do need a social worker to work on placement. Once we have an idea, even a middling idea of placement, then we'll be in a much better position.
Should I reset this to Thursday, Mr. McLean, or do you need longer?
Your Honor, let's try for Thursday because I was hoping the social worker would be physically here, but I don't see them yet. So let's go for Thursday if it's possible.
Okay, I'm on that calendar on Thursday, so we'll reset for 11/2 on Thursday. So Mr. Tuggle, we'll see you back on Thursday, sir.
Thank you, Your Honor.
Okay.
Judge, Union City is ready. They have Mr. Daniels, positions 12 and 13.
Okay, thank you. And have you spoken with Mr. Daniels, Mr. Bartels?
I have, Your Honor.
And what are we going to do with him this morning?
It's going to be a non-negotiated meeting.
Okay. Good morning, Mr. Daniels. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Can you unmute there for me? South Annex? Okay, we're doing this by video. Is that okay with you, Mr. Daniels?
Yes, sir.
Okay, are you able to raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You can put your hand down, sir. Let's see, Ms. Hardy, is there a history?
This defendant has arrests out of a total of 33 cycles with arrests out of Georgia and Maryland. Misdemeanor conviction in 2009 and 2008 for simple battery. 2018 theft by shoplifting. There is a out of Maryland, there is a 2011 misdemeanor assault conviction 4 probation violations and 4 FTAs. Nothing further to report.
Okay, thank you. Ms. Helena Allen.
Thank you, Your Honor. The offer in this case, number 12 is a theft by shoplifting. And number 13 is a failure to appear. And we'll be null crossing number 13 with the plea to position 12. The offer in the case is a 12-month probationary period to serve 292 days, credit for 146 days served, and balance probated. Stay away from the Walmart located at 1105 Research Center. That's a South Fulton location, MHET. So evaluation and any treatment recommendation. And when you're ready, I guess I can talk about the facts. This is non-negotiated. That was the,
Right. So, Mr. Bartels, you have an issue with the MHET?
Well, Your Honor, he served 146 days. The allegation is that he took $52 worth of merchandise from a Walmart. And he would have to be on probation for the MHET. And I think given the amount of time he served in jail, that is more than enough of a sentence. So we would just ask for time served.
Okay. And the request for the MHET, what's the basis?
one moment, from what I can see. It's based on the similar multiple criminal history. That's my understanding.
Well, but from under the statute, Judge, for a third conviction, it's within the discretion of the court to order that if information is presented regarding that. But I don't see why it's something that's just done as a matter of course for every third child. And again, it would require him to be on probation, and I think he's served enough time, more than enough time already.
Okay. From what I'm hearing, if there's nothing more, it'll be a time served plea.
And we do stipulate to the factual basis, and I've advised Mr. Daniels of his options, and he's elected to go ahead and resolve it today. He also did give me permission to sign his name in the paper.
Okay. Let's see, Mr. Daniels, it's my understanding that in case 20 CR 001309J, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You can represent it by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept your plea, Mr. Daniels. The sentence will be 12 months to serve 292 days, credit for time served, 146 days, balance suspended, stay away from the Walmart located at 1105 Research Center in South Fulton. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
Position 6 and 7, Banks. Travis Banks.
This will be a negotiated plea.
That's correct, Your Honor.
Yes, good morning, Mr. Banks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Banks. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Banks. Yes, Mr. Pierre Thomas.
Your Honor, the recommendation from the state in this case is for Mr. Banks to serve, to complete 12 months probation, to serve 24 days in custody, credit for the 12 days that he's already served in custody that appears that he was booked in on October 20th, 2023, to have no further contact with Irisha Stoney, to stay away from the location of 445 Park Ridge Circle in Riverdale, Georgia, 30274, and to complete 40 hours of community service. And if we could have the defense stipulate to venue, factual basis, and identification, as well as if we can sound for the victim, Stoney, in accordance with Marcy's law, that'd be greatly appreciated.
Ms. Stoney is present. You go ahead, Mr. Bartels.
I'm sorry, Judge. We will so stipulate.
Okay, Ms. Stoney is present and wishes to address the court. Now is your opportunity to do so. Anything further, Mr. Bartels?
Nothing, Your Honor. I've advised Mr. Banks of his options. He does indicate he hasn't had any contact with Ms. Stoney in some time. And we would just ask the court to accept the agreement.
To another courtroom.
Okay. Mr. Banks, it's my understanding that in case 22 CR 006922A, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Banks. When you complete the 40 hours of community service, the probation will go to a non-reporting status. So the sooner you get that done, the sooner you don't have to report to probation, and the sooner you don't have to pay those fees, okay? All right, good luck to you, Mr. Banks.
Thank you, Judge.
You're welcome. Who do we have next?
Are you ready for Kilpatrick?
I think there's Mr. Kilpatrick's coming up.
This is gonna be positions 22 and 23, Kilpatrick.
Okay.
Well, it'll be 13 minutes a day. That's all.
Have a seat, Kilpatrick.
That's a non-negotiated plea. Non-negotiated plea, you put it up that way.
What are we doing with Mr. Kilpatrick?
I believe this is a non-negotiated plea, Your Honor, number 22 and number 23. Is that correct?
Okay.
Okay.
Good morning, Mr. Kilpatrick. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, thank you. May I get his history, please? Ms. Hardy?
This defendant has 11 arrest cycles, misdemeanor conviction in 2014 for disorderly conduct, 2023 simple battery family violence, 2 FTAs, nothing further to report.
The 2022, is that case still open or?
The 2023?
Right, the simple battery
Simple
family
battery-
violence.
No, that it was disposed of this year.
And how was it disposed of?
Bear with me one moment.
Right, I tried to explain it. Thank you. Thank you. Let me look through the bill and then- I'll shoot you from there.
While Ms. Hardy looks for that, you can proceed.
Your Honor, the information that I see about a criminal damage to property in the second degree, battery, family violence, cruelty, and willful obstruction is that it has a demand for a speedy trial, pre-indictment motion demand for a speedy trial. So it's a case that's in the DA's office that the defendant has representation on. and is unindicted as of yet. It's an incident from June the 6th of 2023.
Okay, thank you. And as far as the facts of these cases?
Yes, Your Honor. The charges in this case are misdemeanor terroristic threats, 2 counts, as well as a disorderly conduct. On the 30th of this month at about, or right after midnight, police were dispatched to 4120 Fulton Industrial on a report of a male causing physical harm to a female. On scene, police spoke to a security guard, Mr. Allen, who advised that a Dodge Charger had arrived to the gate. A female driver began yelling for help and
Ms. Allen,
advised that
excuse me, just one moment. I think it would be helpful, Mr. McLean, if you all were not speaking and were listening to what was being said so that you could be fully informed. But if you need some time to talk with your client, I'm happy to give you that time, but I would like for you to focus your attention on what the state is saying, if you could.
Understood, Your Honor. We have read the same police report together, and that's why we were having a separate.
Okay, no, that's fine. I just want to make sure that, you know, that you're listening to what the solicitor has to say. So if you have anything that you want to respond to, that you will, you know, that you'll be ready to do that for me. Before I allow her to go on, let me have, I'm just hearing about this open case in the DA's office. Have you spoken with the counsel for him in that case to see what makes the best sense as far as these cases go?
Your Honor, no, we have not, and that's why I suggested to him this would be a not guilty plea today, but he's thinking he wants to go forward. So
I mean, if this is going to affect that case, and that case is obviously a felony case, I would think that you want to speak with that attorney to coordinate the efforts. But if Mr. Kilpatrick doesn't want to do that, I mean, that's his right, but
I wholeheartedly agree with the court. That would be the better course.
Yeah, we could do that.
Okay, yeah, we can do that. Yes,
Because I really didn't do anything.
okay. I mean, I think that behooves him to do that. Let's see.
That was my previous understanding. That works better.
Okay, so would you like to reset this until another time?
Yes, Your Honor. Any quick reset date is fine because the person won't be hard to get hold of by phone.
Okay, we'll reset it for Tuesday, next Tuesday.
Okay, thank you.
Okay, and that's 11/7.
Yes, sir.
Okay, we'll see you back on 11/7, Mr. Kilpatrick.
Okay, and Your Honor, do I still have a bond for this particular case?
Bond has not been changed on anything.
Yes, you still have the current bond that you have on this case, sir.
Okay, thank you, sir.
You're welcome.
Number 8, Benson.
So, without even thinking, we just.
So does he need to be arraigned, or are you gonna file a waiver?
We'll file a waiver of arraignment, Judge. He understands what he's charged with.
Okay, so Mr. Benson, your case is going to be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you.
Thank you, Judge.
Okay. Who do we have next?
Position 26, McColry.
Gotcha. Click to that. Oh, let's see. This is a not guilty and a request for a bond reduction, Your Honor.
Okay. Good morning, Mr. McCorvey.
I know what this.
Morning, sir.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good to meet you, sir. We can proceed. That's
Thank
all.
you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Correct.
Okay. Mr. McCorvey, you've been charged in case 23 CR 006631J with driving while license suspended or revoked, no insurance, and knowingly driving a motor vehicle on a suspended or canceled revoked registration. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusations, Mr. McLean?
We do, Your Honor. We have read them.
How do you plead, Mr. McCorvey? Guilty or not guilty?
Not guilty. This is triple jeopardy. Mr. McLean represented me on this
All
case.
right, okay, Mr. McCorvey, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What's the current bond?
Your Honor, the current bond is, let me flip to it, let's see. Currently, it's 2,500 on driving with license suspended or revoked. It is 1,500 on no insurance. It is 1,000, looks like 600, it's a very small letter there. Looks like 1,600 on the knowingly driving motor vehicle without the registration.
I was traveling, not driving, by the way.
So, hold on. So the total would be, let's see, 5,600 total. That's what I got.
Is this the only thing holding him in?
It is, Your Honor. Now, he's asking the court to consider a signature bond simply, mainly because of the nature of the matter, and he would have to, of course, as we discussed, promise that he would abide by all traffic laws and regulations if the court were to let him out of jail.
Ms. Helen Allen?
Your Honor, the reading that I have of this incident shows that this defendant and his history, so related to bond, I guess, was just convicted for suspended registration and sentenced in February of this year and has multiple active suspensions. This is an incident and arrest from the 23rd of October. And his current license is actively suspended because of failure to appear on multiple violations. And you just heard about his history with multiple convictions for driving without a license and out of state in Florida.
Oh. All right.
I can pull up the police report if there's other questions about what are the underlying facts in this case, but it seems pretty straightforward to me.
It does. Anything further, Mr. McLean?
Nothing further. Thank you, Your Honor.
Can I add something?
No, Mr. McCorvey. I'm not going to hold him in custody on driving offenses, so I'm going to convert the good bonds to signature bonds through the jail. No driving unless he has a valid license, and no drugs, alcohol, weapons while out on bond. If you'll get that to the court,
I will
get it entered. All right. Good luck to you, Mr. McCorvey.
Likewise.
All right. I will prepare that.
Number 14, Dwyer.
Good. Yeah. What number?
14. And this is going to be a negotiated plea, is that right?
That is correct, Your Honor. The state noted in their offers, he actually has a second case. I don't know if that can be heard today. I didn't receive an add-on calendar. But we're prepared to go forward with both pleas. If that's not possible, Judge, he does have a felony charge holding him in. So if we can't do the other case today, maybe it could be reset to Thursday or next Tuesday.
Okay, the felony charge, it won't be, will it be resolved by next Tuesday?
There is no court date. I checked yesterday, Your Honor, and there's not a court date set.
Okay, so why don't we just reset this until next Tuesday?
And I think that way he would like to take care of both cases.
Okay.
That would allow that.
All right.
I apologize. Do we have the case number for the case that needs to be added to next?
Yeah, it's on the calendar,
Oh, it is. I'm sorry, what position?
position 14.
Okay, thank you.
Okay, so we'll add this for next, we'll put these both together for next Tuesday. So we'll see you back next Tuesday, Mr. Fryer.
Thank you, Judge.
This is positions 31 and 32, Randall.
Okay. What's the announcement on Mr. Randall?
Thank you, Your Honor. This is going to be a negotiated plea.
Okay. Good morning, Mr. Randall. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? So is that a yes?
Yes.
Okay, thank you, Mr. Randall. You can place your hand down. Yes, Ms. Helena Allen.
Mr. Randall has two cases, 31 and 32. First case, 19 CR case is a dog at large, reckless conduct, and no Fulton County license tag. That's from February the 3rd of 2019. Position number 32 is a failure to appear related to that case, and that case will be number 32, null prost upon plea to position 31. The offer in this case is for count 1, time served, the dog at large charge, count 2, 12 months, probation, served 24 days in jail, credit for 12 days as of the 20th of this month, balance probated, completeanimalcourts.com, and leave restitution open for the next 30 days. On count 3 would just be a $30 or $100 fine, excuse me. Officers responded to the location at 1085 Pinedale Drive Northwest, where they met with the victim, Mr. Piercer, P-I-E-R-C-E-R, who'd been bitten on the lower leg by the dog owned by Mr. Randall. The dog had escaped from his runner or tether back and forth, I think, and had attacked the victim. That's all the
Okay.
information I have. I think that's relevant.
Thank you. Mr. McLean?
Your Honor, we stipulate to the jurisdiction that is the venue, the identification and the factual basis. He asked the court to go forward. A variation that I don't think makes it an unnegotiated plea is that he wondered if the court could possibly end his probation in an appropriate way, non-reporting or other. Once he completes the animalcourts.com course, that is a $39 online course that he will take. As to the $100 fine, do you need to ask the court to convert that to 10 hours of community service, or do you think you will be able to work on doing the $100 fine itself?
I can make the payments on it.
You can make some payments on it. It will extend your probation into a second month, though, perhaps.
Okay, yeah, we'll.
And that's if the court agrees to terminate your probation on non-reporting or termination.
Yeah, that'll be fine.
And does the state object are asking for termination or non-reporting once he does a course in the fines?
Well, essentially, that would just be no probation at all. And we're asking for restitution to be left open. How does restitution being left open affect that, Your Honor, just for my information?
Oh, I'm sorry.
Well, if he gets, if restitution is determined in the next 30 days, then he'll be on probation until he gets that resolved. If there's no, if you all cannot get restitution in 30 days, then there will be no restitution asked for. So if by the date of the sentence until 30 days, if you've not provided the restitution amount, then he's not going to have to pay restitution. As far as the $100 fine and the animal courts, I will have the probation terminate upon completion of all those terms.
Thank you.
So he'll
No
at least-
objection.
he'll be, at least be on probation for 30 days, to complete, and it may be longer than 30 days if he does not, take the class or pay the fine or restitution when that comes in.
So I just got 30 days.
You're on probation until you complete the condition. The computer course, $39 for all the.
Okay.
Now they're gonna leave restitution open.
30 days.
Not yet. Okay. I believe you understand, now, Your Honor. Thank you.
Mr. Randall, it's my understanding that in case 19 CR 008383H, you wish to plead guilty to dog at large, reckless conduct, and no Fulton County license tag. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Randall. As soon as you get all the terms done, the sooner you won't be on probation, okay?
Yes.
All right, good luck to you, sir.
Judge, can Ms. Joanna Allen go back through the plea one more time, please?
Okay. On Mr. Randall, it's my understanding that
I can go back through it if you
Okay,
want.
all right, thank you.
Count 1 is the dog at large, and that's time served. Reckless conduct is the 12-month probated sentence that the judge just agreed. If he's completed conditions and restitution is determined within 30 days, it can be non-reporting. He'll get credit for the 24 days he'll get credit for the 12 days he served in jail. I think the 24 days we have asked for, he'll get 2 for 1. Is that my understanding? Is that correct?
Yes.
He'll complete animalcourts.com online, and we'll be leaving the restitution open for 30 days. Count 3, no license is $100 fine.
Okay. All right, good luck to you, Mr. Randall.
Okay, thank
Position number 25, Mr. McClendon.
Can I talk to him, please? Can I say something, please?
We need a social worker visit on position 25.
Yes, Your Honor. Now, he may wish to go forward pro se. He sometimes is, might be a little excited, but he might can get through a plea today if it's possible. He is being offered, let's see. Bear with me for just a second while I flip a page. It's the jail portion of his sentence. If he were to accept a plea deal from the prosecutor, the jail portion of his sentence would be up, and he would be on probation. There is a fine involved in NSF courts. And he might wish to accept that today.
Are you representing him, Mr. McLean?
Well, I didn't get quite a chance to start, Your Honor, but if you'd like to talk to me on the phone further, we could discuss it, or it could be pro se, as he indicated, but
Well, if you think he needs a social worker visit, then I'm not going to, until that is accomplished, I wouldn't feel comfortable going forward, given that that would be your recommendation. So I'm happy to reset this until Thursday, possibly, for you to accomplish that.
that does have the advantage of only being 2 days away, and that might be the best course, Your Honor.
Okay, I think I'm going to do that. He appears to be a bit agitated, so if you will have the social worker visit with him and inform us by Thursday, we'll reset Mr. McClendon until Thursday.
Thank you, Your Honor.
Who do we have next?
Hey, Judge Morrow, we're completed here in courtroom 2. The rest of the cases are going to be done on the floors.
Okay, thank you.
Thank you.
So, Mr. McLean? Mr. Bartels?
Sir.
Yes, Your Honor, we're off mute now.
Let's see, position number, I've got that we only have 3 positions left. Position 10, Jermaine Chappelle. What are we gonna do with, or Chapel? What are we gonna do with, Mr. Chapel today?
He is released, Your Honor.
Okay, so position 12 and position 10 is released.
10 is released, yes, sir.
Okay, what about position number 28?
If I can flip to that, I believe that's O'Hara.
Yes.
Although despite the announcement in the proposal section, I was told yesterday that he has been released also. I have not, that was last night, so I've not been to a computer to check, but I believe he's been released and we can check right here and now.
Okay, and it's also my understanding that this was a DA transfer?
Correct.
And it's already been transferred?
It was based on recidivism, so it was not a judgment type call or an opinion, so I believe it has been transferred.
Okay, and the only other case that I have is position 33, and is that Ms. McLeod's case?
33 is, if that's Riley, that's McLeod.
Okay, and Ms. McLeod, I have not seen her with us today. So it appears that this is not, as far as Riley goes, let's reset that 1 week to give Ms. McLeod the opportunity to appear. It doesn't appear that the person would be getting out of custody. So we'll reset that until 11/7.
Who was that?
That's position 33, Ms. McLeod's case.
For next Tuesday?
Yes.
And Your Honor, I did check on Mr. O'Hara. He was released on the 28th.
Okay. So as far as I have, that's all the cases for today. Is that?
That's all that I have, Your Honor.
Okay. All right, so we'll go through the calendar.
Okay.
Ready.
All right.
Fine, you gotta put your shirt up.
Yeah, I picked up on some.
Let me see your keyboard.
What was number? Oh,
Make sure that. Oh, I read it. Yeah.
Position number 1 was waiver arraignment, reset jail jury. Position number 2 was a negotiated plea. Position number 3 was null pros. Position number 4, reset jail jury. Position number 5, waiver arraignment, reset jail jury. Position number 6 was a negotiated plea. Position number 7 was null pros. Position number 8, not guilty, reset jail jury. Position number 9 was a negotiated plea. Position number 10 was a release. Position numbers 11 and 12 were negotiated pleas. Position number 13 was null pros. Position number 14, reset for next Tuesday's SAP calendar, along with its added case 22 CR 002-566G. Position number 15 was null pros. Position number 16 was a negotiated plea. Position number 17 and 18, negotiated plea. Position number 19 was a no-low plea. Position number 20 was null pros. Position number 21 was arraigned, not guilty, reset jail jury. Position number 22 is reset for Tuesday's SAP calendar. Position number 23 is reset for Tuesday's SAP calendar. I missed 24.
Reset 11/7.
Position number 24, reset for Tuesday's SAP calendar. Position number 25, reset for Thursday's SAP calendar. Position number 26 was arraigned not guilty. Well, with an amended bond for 25, 5,600 SOB through the jail, if I added it correctly. 27 and 28 were released. 29 and 30, negotiated plea. Position number 31, negotiated plea. Position number 32 was null pros. Position number 33 and 34 reset for Tuesday's SAP calendar. Position 35 is reset for Thursday's SAP calendar, and position number 36 is a negotiated plea.
Okay, questions, concerns?
Who do I need to send no pros orders to?
Ms. Strong?
Okay.
All
Yeah,
right.
I've got, number 18 was a null cross. 17 was a plea and 18 null cross.
Oh, I'm sorry. It was supposed to be a null pros. Thank you, Mr. Bartels.
Okay, nothing further. I will see you all next, on Thursday. All right.
Yeah,
Thank
we'll-
you, guys.
I'll go ahead and travel back to the 100 Peachtree Street building, so.
And send your amended bonds, please.
Okay.
Yes, slight
Thank
delay
you.
from travel.
Yeah.
I'm not stopping for lunch.
Please don't. Thank you.
Y'all be
Thank
safe.
you.
Okay, see you next time.
It's only 11 o'clock, it's not time for lunch.
We just,
We just,
got some good deals. Good, non-